She thought the judge would side with her based on sympathy alone. I relied on documentation, structured accounts, and the prenuptial safeguards. The court ruled by contract, not emotion. She looked unprepared for that outcome. You're going to lose everything in that courtroom, and you know it. She said it with the kind of confidence that only comes from someone who has never actually been tested. She was standing in the kitchen doorway, arms crossed, wearing that expression she'd perfected over 6 years of marriage, the one that was supposed to make me feel small. I looked at her for a long moment. Then I picked up my coffee, took a slow sip, and said, "We'll see." That was the last real conversation we had before the attorneys took over everything. Hey viewers, before we move on to the video, please make sure to subscribe to the channel and hit the like button if you want to see more stories like this. I'm 41 years old. I built a mid-sized logistics consulting firm from a shared office space and 2 borrowed laptops. By the time I married Vivian, I had 3 corporate contracts, 11 full-time employees, and a property portfolio that my accountant called impressively structured for someone your age. I say that not to brag. I say it because it explains why, when my attorney first suggested a prenuptial agreement, I didn't argue. Vivian and I met at a conference in Denver. She was working for a marketing agency at the time, freelancing on the side, sharp with words and sharper with first impressions. She laughed at the right moments and asked the kind of questions that made you feel like you were the most interesting person in the room. I was 34 and tired of casual. She was 31 and said all the right things about wanting something real. We dated for 2 years before I proposed. I thought 2 years was enough time to know someone. I was wrong about that. The prenup conversation happened on a Sunday afternoon in late October, 4 months before the wedding. My attorney, a careful and precise man named Colin, had drafted a 12-page document that outlined asset separation, income earned before and during the marriage, property rights, and conditions for spousal support. I handed Vivian a copy and gave her a week to review it with her own legal counsel. She came back 3 days later and said she found it insulting. "It feels like you're planning for us to fail," she said. I remember being very calm about it. I told her I planned for my business to succeed too, which was exactly why I had contracts, insurance policies, and contingency budgets. She didn't like that answer, but she signed. Her attorney had requested 2 minor modifications, both of which Colin approved as reasonable, and the agreement was finalized, notarized, and stored in 3 separate places: Colin's office, my private safe, and a digital encrypted archive that my IT consultant managed. That level of documentation would matter more than I could have predicted at the time. The first 2 years of marriage were genuinely good. I want to be honest about that because it would be easy to look back now and rewrite the whole thing as a slow disaster from the start. It wasn't. We traveled together well. She was funny when she wanted to be, and she had this quality of making ordinary evenings feel like they meant something. We had real conversations about real things, about ambition, about what we wanted the next decade to look like, about whether we wanted children. We decided we didn't, at least not yet, and that felt like a shared decision made by 2 people on the same page. Then year 3 happened. It started small, the way most things do. She left her freelance contracts and said she wanted to focus on building something of her own. I supported that completely. I gave her space in the home office, covered all shared expenses so she wouldn't feel financial pressure, and told her to take whatever time she needed. 6 months in, I asked casually how it was going. She said it was in the development phase. I didn't push. Another 4 months passed. I noticed she was spending more time on her phone, more time meeting with potential collaborators, more time coming home later than she'd said she would. I noticed, but I didn't say anything yet. I've always believed that surveillance without cause is its own kind of relationship poison. So I waited. I paid attention the way you do when something feels off, but you can't quite name it yet. The first concrete thing I found was a credit card statement. Not because I was snooping. We had a joint card for household expenses, and I reviewed the statements as part of our monthly budget check. There were charges I didn't recognize. 2 dinners at restaurants I'd never been taken to. A hotel charge for a Friday night in a city 40 minutes from ours. A spa appointment for 2. I set the statement aside and didn't mention it that night. The next morning, I photographed every page of it and saved the file with a date stamp. I didn't know exactly why I did that. Instinct, maybe. Or maybe some part of me had already started doing the math. Over the following 3 months, I quietly started keeping records. I wasn't dramatic about it. I didn't hire a private investigator, didn't go through her phone, didn't confront her with accusations I couldn't support. I simply began maintaining a detailed personal log, dates, times, anything she told me versus what the receipts and evidence actually showed, inconsistencies in her stories, patterns in her schedule. I saved everything to the encrypted archive. I logged credit card activity, noted when her explanation for an expense didn't match the vendor category, and began keeping a separate account of our shared finances to establish a clear baseline of where money was going. Colin, my attorney, didn't know I was doing any of this yet, but when I eventually brought him that folder, he told me it was some of the cleanest documentation he had seen a client produce outside of a formal investigation. The moment I knew for certain came on a Wednesday evening in March. Vivian had told me she was attending a branding workshop that ran until 9. At 7:43 p.m., she sent me a text saying it was running late and she'd be home by 10:30. I happened to be meeting a client for dinner that same evening at a restaurant on the other side of the city. My client was 45 minutes late, so I stepped outside to take a call. And there, at a small table through the window of the wine bar directly across the street, was Vivian, sitting across from a man I had never seen before. Not sitting the way colleagues sit. Not sitting the way friends sit. I stood there on the sidewalk for approximately 20 seconds. Then I went back inside, finished my client dinner, drove home at a normal pace, and when she arrived at 10:52 p.m. with a story about the workshop running over, I listened to the whole thing without interrupting. I said, "Sounds like a long day. Get some sleep." She kissed me on the cheek and went upstairs. I sat in the living room until almost 2 in the morning, and I thought very carefully about what I wanted to do next. I called Colin the following morning. I told him I needed a private meeting, not over the phone, and that I'd explain when I got there. He cleared time for me that afternoon. I laid out everything. The folder, the photographs of the credit card statements, the log I'd been keeping, and what I had witnessed the previous night. Colin was quiet for a long moment. Then he said, "How long have you been keeping this documentation?" I told him approximately 3 months. He nodded slowly. He said, "We're going to go through all of this very carefully, and then I'm going to explain to you exactly what your position looks like." That meeting lasted 2 hours and 40 minutes. When I left his office, I had a clear understanding of what the next steps were going to look like, what the prenup covered and what it didn't, and what I needed to do in the short term to protect my assets before anything was filed. I didn't move immediately. Colin advised me to spend another 30 days continuing to document, making no financial moves that could be characterized as retaliatory or preemptive in a way that would look bad in court, and to consult with my accountant about the current state of all business and personal accounts so we had a clean, dated snapshot. Those 30 days were the strangest of my life. I came home every evening and had dinner with my wife. We talked about ordinary things. She suggested we look at taking a trip to Portugal in the fall. I said that sounded like something we're thinking about. I was not being cruel. I was being careful. There is a difference. At the end of those 30 days, I had everything Colin had asked for. Business valuations with independent verification dates. A clear accounting of every shared and personal asset. A continuation of the personal log that now stretched across 4 months. And one additional piece. My IT consultant had flagged unusual activity on the shared cloud storage we used for household documents. Files had been accessed and in some cases downloaded that had no obvious reason for being opened, specifically folders related to my business income, property deeds, and the prenuptial agreement itself. We documented that too. I didn't know at the time exactly how significant that would become, but Colin said, "Keep it. All of it." I filed for divorce on a Thursday morning in April. Vivian found out when her attorney called her that afternoon. I had already moved out of the master bedroom the week before, citing sleep problems, which wasn't entirely a lie because I hadn't been sleeping well for months and had been staying in the guest room. When she came home that evening, I was in the living room with a book I wasn't actually reading. She stood in the doorway with her phone in her hand and looked at me like I had become a stranger. "You filed," she said. "I did," I said, without even talking to me first. I set the book down. "Vivian," I said, "I think we both know there were things that should have been talked about long before this." She stared at me for a long moment. Then she said, "You're going to regret this." I didn't answer. She went upstairs. The house was very quiet after that. The next 6 weeks were a kind of controlled chaos. Her attorney filed a response that challenged the scope of the prenuptial agreement on 3 grounds. The first argument was that the agreement had been signed under what her attorney characterized as pressure and unequal legal representation. The second was that certain assets acquired during the marriage should be considered marital property regardless of what the prenup specified. The third was a claim for spousal support based on the argument that Vivian had set aside her professional career to support the marriage and was now in a disadvantaged financial position. Colin read through all three arguments with the calm of someone who had heard them before. He said, "The first argument is going to fail." She had independent legal counsel and 3 days of review before signing. He said, "The second argument has some surface logic to it, but the prenup language is specific and the asset trail is well documented." He said, "The third argument is the one they're actually betting on." He was right about that. The spousal support claim was built around a narrative. Her attorney was constructing a picture of a woman who had sacrificed her career, her professional identity, and her earning potential to support a husband who had benefited enormously from the stability she provided at home. The narrative was not entirely without truth. She had stopped freelancing. She had not built the business she talked about. She had been home more than she worked for the last 3 years. What the narrative conveniently omitted was that she had been given every resource and opportunity to pursue her own work, that the decision not to work had been entirely her own and had never been requested or expected by me, and that her time not spent working had not, in fact, been spent supporting the household in any measurable way that would be difficult for me to document. Because I had documented it. The household accounts showed that the majority of domestic management, bills, scheduling, maintenance coordination, all of it, had been handled primarily by me, with the assistance of a part-time household manager we'd hired in year 2. Vivian's actual contribution to domestic operations, when mapped against the records, was minimal. I had the receipts, the schedules, the correspondence with service providers, and the time-stamped account records to prove it. The first pretrial hearing was where I got my first real read on the judge. His name was Judge Calloway, late 50s, silver-haired, the kind of man who had clearly heard every variation of every divorce argument in existence and was not particularly moved by any of them. He reviewed the preliminary filings, asked a series of very precise questions about the prenuptial agreement, and made 2 observations that I filed away carefully. The first was that he viewed prenuptial agreements as legally binding instruments that required a very specific and well-supported argument to challenge, and that emotional duress was not a standard that would be easily met. The second was that spousal support claims were evaluated on documented financial need and demonstrable earning capacity, not on subjective narratives about sacrifice. Vivian's attorney smiled through all of this like he knew something the judge didn't. I noticed that Vivian herself looked confident. She was dressed carefully. She had clearly been coached on how to present herself. She sat with a quiet kind of dignity that I recognized. It was the same expression she wore when she was performing composure she didn't actually feel. I had seen it many times. I said nothing. Colin said nothing. We already knew what we had. The deposition phase was where her case started showing its cracks. Depositions are strange things. They're not dramatic in the way that courtrooms are. They happen in conference rooms with fluorescent lighting and mediocre coffee. But they are where truth tends to surface because there is no audience to perform for and the questions don't stop until the answers run out. Vivian's deposition lasted 4 hours. Colin handled it with the methodical patience of someone who wasn't in a hurry to get anywhere. He asked her about the credit card charges. She had explanations for some of them and vague uncertainties about others. He asked about the hotel charge. She said she had gone alone for a personal retreat, something she did occasionally. He noted the charge was for 2 guests. She said the hotel must have made an error. He produced the hotel's booking record. There was a silence in that conference room that lasted several seconds. Her attorney said, "My client will need a moment." Colin said, "Of course." He asked about the man I had seen her with through the wine bar window. She said she didn't know who he was specifically, but that she met with various people professionally. He asked if she could provide any professional documentation connecting this individual to her work. She said her records weren't organized in a way that would easily produce that. He asked about the cloud storage access, the business documents, and the prenup that had been downloaded from our shared system. She said she was reviewing documents related to the marriage as part of her own process. He asked why she had accessed business income records that were not hers under the terms of the prenup. She said she was trying to understand her own financial situation. He noted that accessing your spouse's protected business documents without authorization was a meaningful act, especially when that access occurred in the months before a divorce filing. Her attorney objected. Colin withdrew the question, but it was already in the record. My own deposition was shorter and considerably less eventful. Her attorney tried several angles. He asked about my emotional availability in the marriage. He asked whether I had been supportive of Vivian's professional ambitions. He asked whether I had, at any point, discouraged her from working or made her feel that her career was less important than mine. I answered every question honestly and specifically, and in each case I was able to reference a documented instance, an email I had sent encouraging her, a conversation I had logged, a record of the resources I had made available to her. Her attorney didn't have a lot of room to work with. At one point he asked why I kept such detailed records of my personal life. I said I ran a consulting business that relied on precision, documentation, and accountability, and that those habits extended into all areas of my life. He stared at me for a moment. Then he moved on. Colin brought in a forensic accountant to produce an independent analysis of all marital finances. The analysis confirmed what our records had already shown, that my business assets were clearly delineated per the prenup, that the shared marital accounts had been funded primarily by my income, and that Vivian had no independent income or investment during the marriage that would constitute separate marital property on her side. It also flagged something I hadn't noticed. Over the course of approximately 2 years, there had been a pattern of cash withdrawals from our joint account that totaled a significant sum. The withdrawals were spread out, usually under amounts that would trigger automatic scrutiny, and they had been made from ATMs in locations that didn't correspond to our normal areas of activity. I had not been paying attention to the joint account at that level of detail. The prenup did protect my separate assets, but the joint account was technically marital property, and the withdrawals were coming out of a shared pool. Colin said this was potentially useful, not because we needed the money back necessarily, but because it demonstrated a pattern that would be relevant to the court's overall assessment of the parties' conduct during the marriage. Her attorney's courtroom strategy became clear during his opening statement. He was going to appeal to the human element. He painted a picture of a woman who had entered a marriage with full faith, who had given up the trajectory of her professional life, who had poured herself into building a home and supporting a driven and often absent husband, and who was now facing the prospect of walking away from a 6-year marriage with essentially nothing because of a document she had signed before she fully understood what her life would look like inside that marriage. He was good. I'll give him that. He spoke in a way that was calibrated to produce emotional resonance. He paused at the right moments. He looked at the judge with the kind of measured seriousness that said, "This is a matter of fairness, Your Honor, not technicality." Vivian sat at the table with her hands folded and her expression carefully neutral. She looked like someone who had been through something difficult and was holding herself together with quiet dignity. It was a good performance. Colin's opening statement was 3 minutes shorter. He didn't try to match the emotional register. He outlined the prenuptial agreement and its legal standing. He stated that the agreement had been entered into voluntarily by both parties with independent legal counsel. He said that the evidence would show the financial records, communication records, and documented conduct of both parties throughout the marriage. He said the court would find a clear and thoroughly evidenced record on our side of this case. He said, "This is a contract dispute, Your Honor. We'll treat it as one." Then he sat down. The first witness called by her side was a friend of Vivian's, a woman named Cecile who had known her since college. Cecile spoke about how much Vivian had loved the marriage, how invested she had been in making it work, how she had talked about putting her husband's stability ahead of her own ambitions. She spoke with genuine emotion. She clearly believed what she was saying. Her attorney asked her to describe any specific instances where Vivian had discussed giving things up for the relationship. Cecile described several conversations. Colin's cross-examination was brief and surgical. He asked Cecile whether she had direct knowledge of Vivian's professional activities or financial decisions during the marriage. She said not directly, no. He asked whether she had any first-hand information about how the household was managed or who primarily handled its financial operations. She said she wouldn't know the specifics. He thanked her and sat down. The second witness was a career consultant who had been hired to assess Vivian's current earning potential. The consultant concluded that Vivian would face a re-entry challenge into the professional market after her years away and projected a significant income gap over the next 3 years compared to what she would have earned had she maintained her career continuously. It was a solid piece of expert testimony. Colin had anticipated it. He cross-examined the consultant carefully. He asked what the consultant's analysis was based on regarding Vivian's career at the time of marriage. The consultant cited her stated work history. Colin asked whether the consultant had reviewed any documentation of the professional opportunities or resources available to Vivian during the marriage that she had not pursued. The consultant said that information had not been provided to her for review. Colin submitted into evidence the correspondence between myself and Vivian over the course of 3 years, emails, text threads, and written notes, in which I had repeatedly and specifically encouraged her to pursue her work, offered to fund any business venture she wanted to start, and asked her on multiple occasions whether there was anything she needed from me to make her professional goals more achievable. The consultant reviewed a summary of the submission. Her assessment shifted, notably. Then came Vivian herself. She was composed on the stand. Her attorney walked her through a prepared narrative with practiced ease. She described the early years of the marriage as beautiful but busy, and how she had gradually come to feel that the life she had imagined building for herself was being quietly outpaced by the life she was building around me. She said she had tried to launch a business but felt unsupported. Her attorney asked in what way she had felt unsupported. She said emotionally that she had needed more presence and encouragement, and that while resources were available, emotional backing was not. It was a carefully chosen framing. Resources were present. She couldn't deny that. But the argument was about something softer and harder to disprove. She said she had felt alone in the marriage in ways that made it difficult to take professional risks. She said she had loved her husband and had hoped for a different outcome. Her voice caught in exactly the right place. Several people in the room shifted in their seats. Colin's cross-examination began quietly. He asked Vivian to describe her typical week during the 3rd and 4th years of the marriage. She did. He asked who had managed the household accounts during that time. She said it had been primarily managed jointly. He submitted the account records showing that the primary account manager on record, all service provider communications, and the majority of financial decisions had been executed under my authorization and signature, not hers. He asked about the credit card charges from the joint account. She gave the same answer she had given in the deposition. He produced the hotel's booking records again, now entered as formal evidence. Her answer on the stand was essentially the same as in the deposition, an error by the hotel. He asked why no correction to the charge had ever been requested or disputed. She said she hadn't gotten around to it. He moved on. He asked about the cash withdrawals from the joint account. She said she had used cash for personal expenses occasionally. He asked whether she could provide any corresponding receipts or records for purchases totaling the cumulative withdrawal amount over that period. She said she didn't keep detailed records of cash spending. He said he understood. He submitted the forensic accountant's documented finding of the pattern anyway. The exchange that I think changed the room happened about 40 minutes into cross-examination. Colin asked about the prenuptial agreement. He asked whether Vivian had felt pressured at the time of signing. She said yes. She had felt that refusing to sign would have created serious conflict in the relationship. He asked whether her attorney at the time, a woman named Adiz, who had 15 years of family law experience, had advised her on the document. She said yes. He asked whether Adiz had communicated to her that she had every right to decline signing. There was a pause. She said yes. He asked whether she had signed of her own free will with that understanding. Another pause. She said she had felt she didn't have a real choice. He submitted the signed client communication form from Adiz's office, a standard document that clients signed confirming they had received legal advice, understood their right to decline, and were signing voluntarily. It had Vivian's signature on it. Her attorney objected that the document was being taken out of context. Judge Qley reviewed it quietly and overruled. Her attorney's closing argument leaned heavily into the emotional narrative. He talked about fairness. He talked about the spirit of marriage versus the letter of contract. He asked the court to consider what kind of precedent would be set by rigidly enforcing a document signed by two people who could not have fully foreseen the shape their lives would take. He used the word humanity 3 times. He was asking the judge to feel something. Colin's closing was measured and direct. He went through the prenuptial agreement clause by clause and mapped each point of contention against the documented evidence we had produced. He addressed the emotional support argument by noting that the standard for spousal support is not subjective emotional experience, but demonstrable financial need and documented earning capacity impact, and that the record showed clearly that Vivian's choices during the marriage were her own and had not been constrained by external pressure or lack of opportunity. He noted the cash withdrawals. He noted the hotel records. He noted the cloud document access. He did not present these as moral accusations. He presented them as part of a documented pattern that the court was entitled to consider when assessing the overall credibility of the claims before it. He said, "Your Honor, this agreement was signed by two adults with full legal counsel and full understanding of their rights. The evidence in this case supports its enforcement completely and without exception." He sat down. Judge Qley did not rule from the bench immediately. He said he would review the submitted evidence and issue a written ruling within 30 days. Vivian and her attorney spoke quietly at their table. I gathered my files. Colin put a hand briefly on my shoulder and said nothing. We walked out of the courtroom into a hallway that smelled like floor cleaner and recycled air. He said, "That went well." I said, "You think?" He said, "I think the judge is not a man who makes decisions based on how things feel. And our case was built on how things actually were." The written ruling arrived 26 days later. Colin called me before I received my copy. He said, "I want to go through it with you in person." I went to his office that afternoon. He had printed it out and highlighted the relevant sections. Judge Qley's ruling was 11 pages. The first section addressed the challenge to the prenuptial agreement's validity. He found that the agreement had been entered into voluntarily by both parties, that both parties had received competent independent legal counsel, that the review period was adequate, and that there was no evidence of coercion or misrepresentation at the time of signing. Challenge 1. Rejected. The second section addressed the marital property claims regarding assets acquired during the marriage. He found that the prenuptial agreement had clearly and specifically delineated how assets accumulated during the marriage would be categorized, that the documentation of those assets was comprehensive and credible, and that the claims for additional marital property division were not supported by the evidence. Challenge 2. Rejected. The third section, the spousal support claim, was the longest. Judge Qley wrote that spousal support determinations must be grounded in documented financial need and a credible assessment of earning capacity impact. He noted that the record showed Vivian had access to significant resources throughout the marriage, had been encouraged on multiple documented occasions to pursue professional activities, and had made the choice not to do so. He wrote that the career consultant's testimony, while competent, had been based on incomplete information and had not accounted for the documented opportunities available to the claimant during the marriage. He noted the forensic accountant's finding regarding the pattern of cash withdrawals. He noted, carefully and without dramatics, that certain elements of the claimant's testimony were inconsistent with documentary evidence submitted by the respondent. He awarded minimal transitional support, 3 months at a figure that was a fraction of what her attorney had requested, citing the short transitional period as appropriate given the circumstances of the case. Then he enforced the prenuptial agreement in its entirety. Colin set the ruling down on the desk between us. He said, "She's going to appeal. Her attorney has an obligation to tell her she can." I said, "Let her." He said, "Appeals are slow and expensive and this record doesn't get better for her with time. I think her attorney will advise her to settle the appeal question quickly." He was right about that too. Her attorney filed a notice of intent to appeal within 2 weeks. Within 30 days of that, he withdrew it. I never found out exactly what conversation happened between him and Vivian. I imagine it wasn't a pleasant one. I ran into Colin's paralegal in the building lobby a few weeks after everything was finalized. She told me, without me asking, that in her years working these cases, she could usually tell in the first hearing which side had actually done the work. I asked what she meant. She said that people come into these proceedings with 2 different kinds of preparation. Some people prepare a story. Some people prepare evidence. She said the ones who only have a story usually figure out too late that the courtroom is not a place where the most compelling narrative automatically wins. I thanked her for saying it. I drove home. In the weeks after the finalization, I went through a period that I didn't fully expect. Not grief, exactly. Not relief, either, at least not right away. Something quieter than both of those. I'd spent evenings in the house. I'd stayed in it, which the ruling had confirmed was mine under the terms of the prenup, and I'd sit in rooms that used to feel shared and just exist in them for a while. I wasn't angry. The anger had burned off somewhere during those 30 days of careful documentation and controlled dinner conversations and strategic silences. What was left was something closer to clarity. My accountant came by one Saturday morning to finalize the post-divorce account restructuring. He's a methodical man, not given to personal commentary, which is one of the reasons I've worked with him for 11 years. But at the end of our meeting, as he was putting his files away, he looked up and said, "You handled that the right way." I asked what he meant. He said, "I've watched people go into these situations with nothing but hurt feelings and a sense of moral certainty, and they get taken apart. You walked in with a paper trail and a plan." He said, "That's what made the difference." He closed his briefcase. He said, "See you in April." He left. I thought about what he said for a long time afterward. Not because it made me feel vindicated. I was past wanting vindication by then. I thought about it because it was true, and because the truth of it said something uncomfortable about how most people approach the hardest situations in their lives. When something feels personal, when it cuts deep and involves people you trusted and decisions that shaped years of your existence, the instinct is to respond with emotion, to go in hot, to want the other side to understand how much damage they caused, to want the room to see you as the one who was wronged. I understand that instinct. I felt it. There were nights in the early stages of this where I wanted to confront her with everything I knew, to watch her realize that I'd been watching, to have the kind of scene that feels satisfying in the moment and useless in the aftermath. I didn't do any of that. I made a folder. A colleague of mine, someone I've known for years through the industry, a man named Derek who has been through his own version of a difficult divorce, took me to dinner about a month after everything was finalized. He asked how I was. I told him honestly that I was okay, which surprised me as I said it, because I thought I'd feel worse. He said, "You know what I did wrong in mine?" I said, "What?" He said, "I tried to win the argument instead of winning the case." He said he had spent so much energy trying to prove that he was the better person, the more wronged party, the one who deserved sympathy, that he had walked into his proceedings without half the documentation he needed. He said his attorney had been frustrated with him. He said the ruling had not gone in his favor on several points where it might have, if he'd been better prepared. He said, "The court doesn't care who was right in the relationship. It only cares what you can prove." I raised my glass. He raised his. We didn't say much more about it. There is something I've thought about often since then, the question of what Vivian actually believed would happen. Because I don't think she was simply arrogant. I think she genuinely believed that the emotional weight of her narrative would carry the day. I think she had been told, or had convinced herself, that the story of a woman who had given years of her life to a marriage and walked away with the terms of a prenup was a story no reasonable judge could uphold without modification. She believed the room would feel something. She believed feeling something was enough. She wasn't entirely wrong about the room feeling something. Her attorney was skilled, and Cecile was a compelling witness, and Vivian herself was convincing on the stand in the ways she needed to be. But Judge Calloway was not ruling based on what the room felt. He was ruling based on what the evidence showed, and the evidence was very clear. I had a conversation with Colin after everything was settled, not about business, just one of those longer conversations you end up in with people who have been through something significant with you. He said that in his experience, the most dangerous assumption a client on either side of a divorce could make was that the judge would do the work of building their case for them. He said people came in expecting that the obvious moral weight of their position would be self-evident. He said, "The judge doesn't know you, doesn't know who cried more, who tried harder, who deserved better. He knows what's in front of him." He said the ones who won were the ones who put into the record exactly what they needed the judge to see. Everything else, he said, is just noise. I sold the house 8 months later. Not because I had to. It was mine, and the ruling confirmed it. But because living in it alone felt like a choice I was making every day, and after a while I decided it wasn't the choice I wanted to make. I bought a smaller place on the other side of the city. A top-floor apartment with good light and a view of the park. I put a desk in the second bedroom and started working from home more often. The business had a strong year. I hired 2 new people in the fall and promoted someone I'd been watching for a while. I took a solo trip to Copenhagen in November. I had never traveled alone before, not really, and I found that I liked it more than I expected. There's a version of this story I could tell where I'm the one who has everything figured out and walked through the whole ordeal with cold precision and zero emotional cost. That version would be a lie. There were weeks in the middle of that year where I felt the full weight of what had happened. Not just the betrayal, but the years of context behind it. The way you catalog every moment you trusted someone and look at those moments differently when the trust turns out to have been misplaced. There were nights where the documentation felt like a strange comfort and a strange grief at the same time. Because keeping records of your marriage falling apart means you have very specific evidence of exactly when and how it happened. That is not a painless thing to sit with. But I'll tell you what I don't feel. I don't feel like the courtroom was the place where the real verdict came in. The courtroom just handled the legal architecture of an ending that had already happened. What I do feel, with a steadiness that has only grown since then, is something like respect for the process of being prepared, not as a coldly strategic act, not as a lack of emotion, but as a form of self-respect, as a recognition that the things you've built and earned and structured deserve to be protected with the same intention you used to create them. You don't leave the important things to chance. You don't trust that the room will understand you. You show the room what it needs to see. The prenuptial agreement that Vivian had called insulting on a Sunday afternoon in October, for years before everything unraveled, the one she signed after her own attorney advised her and cleared the path for her to walk away from, held up in every clause. Not because it was written in a particularly unusual way. Collins said later it was a fairly standard agreement for someone with my asset profile. It held up because it was clear, it was witnessed correctly, it was entered into by both parties without duress, and because when it was challenged, we had 4 months of documentation and a forensic accountant's report and a hotel booking record and a pattern of cash withdrawals to build the picture that the contract alone could not fully paint. The contract was the foundation. The documentation was the structure on top of it. Neither one alone would have been enough. Together, they were. I think about Vivian sometimes. Not often. Not with anger. Just in the way you occasionally think about someone who was a significant part of your life for a specific chapter of it, and who turned out to be a different person from the one you thought you were building something with. I hope she figures out what she actually wants. I hope she finds a way to pursue it that doesn't require borrowing from someone else's work without their knowledge. I hope she builds something she can actually call her own. Those aren't bitter thoughts. They're genuine. I mean, all of them. The last time I saw her was in the courthouse parking lot, the day the ruling was issued. She was walking to her car. I was walking to mine. We were 20 feet apart. She looked at me. I looked at her. Neither of us said anything. She got in her car. I got in mine.